Hi everyone. Today we're going to talk about a topic that makes a lot of people that are immigrants in the US very anxious, and that is traveling. Traveling while you are seeking a green card. So, for example, you're a student or you are a worker in the US and you're applying for a green card. What happens if you need to travel or you want to travel to see family, friends, or just for pleasure? So before we jump in today's topic, I wanted to offer the disclaimer that I am not a legal advisor. I'm not an immigration attorney. I'm a person that went through this self-petitioning process for a green card, and this is the information I gathered from multiple sources. And if you are in a situation where you have to travel, the best thing that you can do is to consult with an attorney and make sure that you're doing things right. So in today's presentation, we're going to cover traveling during the green card process. My website, EB2NIW.info, focuses on EB2 NIW category, but this is really applicable to any type of green card, and we're going to cover the general situations where one might find themselves in. So we're going to cover traveling during I-140, which is the first part of the EB2 NIW process or a green card process, and then during the I-485 application, which is the adjustment of status. So while the I-140 is pending, you may or may not travel depending on what visa are you on. Of course, we're assuming that you're already in the United States. So there are two main categories of visas depending on the immigration intent. The dual intent visas, for example, an L on H visas. H is the very famous H-1B visa is one of these H visas that are working visas. These are dual intents, and what it means is that you don't have to demonstrate that you are really going back to your country of origin after your visa is over, and you may be seeking permanent residency in the United States. So if you are a holder of a valid L or H visa, the I-140 should not have any impact on your ability to re-enter. And mm, really pay attention to the fact that I'm saying a valid L or H visa. Of course, if your visa is expired, that is a problem. You cannot re-enter the country under your visa. You would have to either renew it or find a different solution. But this is actually a case where I was in. Um, I was on an H visa, so you can always go outside the US and come back as an H holder. The green card process has no impact on your visa status, and you can re-enter under your H visa in this case, as long as it's current. So O visa, actually, I did a little bit of research about that. O visa is a visa that is for individuals with extraordinary abilities. Is similar in some ways to the green card EB1, but it's a temporary visa. It's not a green card. You have to fulfill many of the of the similar requirements than EB1 holders had to, but it's temporary. I have seen conflicting information out there about if this is a dual or dual intent or not type of visa. I finally found this Department of State's Foreign Affair Manual that is very clear, stating that the O visa is dual intent. So since this is the case, then O1 visa holders should be in a similar situation than what we just talked about, the L and H, so dual intent visa holders. So you can travel outside. You should be able to do that and come back and use your O1 visa as long as the O1 visa is current. A different story, unfortunately, is non-immigrant visa holders, and those are visas such as the J, F, or B. F is a very common visa because the student visa, and that includes people that are doing their OPT period. That's a training period where you can actually find a job in a company of the of the field of studies. In these situations, it is generally not advised to travel. These visas are non-immigrant intent visas, which means that the US expects you to go back to your country after your visa is over. So that's why if you go outside the US while you have already applied for a green card and file your I-140, when you try to re-enter, even if your visa is current, the officer at the border may deny your entry because you have shown that you do have an intent to immigrate in the United States permanently. And that kind of goes against to the classification of the visa you are using. So you really don't want to find yourself in that situation. And generally, the recommendation is to not travel abroad. Of course, if you have to travel abroad because sometimes emergencies happen, you should consult with a lawyer. Now, let's move into the second part of the green card application. Once you have your I-140 approved, and you are waiting for your I-485, your adjustment of status, then what is the situation there? So when you apply for I-485 adjustment of status, you can also apply for what is called advanced parole or form I-131. If you get that approved, then you obtain what is called a travel document, which would allow you to travel and re-enter the country. However, you should consider carefully your situation before taking the travel document and re-entering the country using this advanced parole. Because if you re-enter the US using this travel document, and eventually your adjustment of status is denied, then you may find yourself out of status because you have re-entered the country using your green card application. So you are no longer using your visa. Your visa is now gone. And if something were to happen to your green card application and is denied, then you are suddenly out of status. So you really need to consider carefully what you should do. Of course, this is a personal decision. You can also consult with a lawyer and see what makes sense. And again, your current visa also matters, and we'll see now why. So if you are under a dual intent visas, again, that would be, for example, L or H visas, you can actually travel outside while you're waiting for your I-485, sorry, to be approved, and you can re-enter as long as your visa is valid. You can just re-enter with your visa. You don't have to use your travel document, your advanced parole. You can just you can have that just in case as a plan B, but you can actually use your visa, re-enter, and you are still under that visa. So now if something bad happens with your adjustment of status for the green card, you still have something to fall back to, which is your visa. So you can travel, you can come back, use your visa, don't use your green card at that point because it's not fully approved. And and of course that applies if the visa is valid. If not, that's a totally different story. An exception to this is if someone already used the EAD card. So also when you receive this travel document, typically at the same time you receive an employment card that allows you to already work under that green card even before it is fully approved, even before you get your adjustment of status approved. So if you have changed jobs and you have used that EAD card before getting the green card, then this benefit of the dual intent visa doesn't apply because you already used the green card for changing jobs. In that case, if you need to travel, then you can consider using the advanced parole or the travel document to re-enter the country. Non-immigrant visas, or better said, non-immigrant intent visas, those are B, J, F, including OPT, generally is not advised to travel. And that's because these visas are non-immigrant intent visas, and the US considers that you have a residence abroad where you will go back to. And so filing I-485 adjustment of status for your green card doesn't impact your visa status. You can stay in the country under your visa and that's no problem. But as soon as you go out and attempt to re-enter the US, then you can be rejected at the port of entry, for example, at the airport. And that would mean that now you are out of status. Tricky situation here, and of course you can always consult with a lawyer and see what are your options, but in general, it is not advised to go out and return to the US. Okay, so in conclusions, traveling with a green card petition pending may not be advisable depending on the situation. So if you are an individual that is on a dual intent visa and the visa is current, you shouldn't have any issue going outside of the country and coming back to the US using your visa that is valid. The application for a green card does not have an impact on your visa, and even traveling out and in doesn't affect your status. However, if you are in a non-immigrant intent visa, and those are visas like the student visas, then you may have issues if you go outside and you re-enter the US while you're waiting for your green card petition to be resolved. Once you have your adjustment of status filed and you have a travel document, you may choose to use your advance parole to re-enter the US, but then if your adjustment of status fail, you may be out of status. So basically, you are putting all your betting on your green card to be approved, and you're already giving up on your student visa or whatever type of non-immigrant intent visa you are on. So in general, if you can wait to travel, that would be better. But of course, there's a lot of situations where that's not a choice. In that case, it's always good to consult with a professional lawyer. This is general information, what we discuss here today. This is a complicated topic, as all the topics that involve green card and immigration status. And again, this is only for educational purposes. I am not an attorney. You should definitely consult with a professional if you are thinking about traveling. You should hire someone, pay them for a session of consulting, and really let them assess your situation, because each situation is unique. Good luck in your travels, good luck in your immigration process, and I'll see you in the next video. If you have any questions or you want to know more about the EB2 NIW category, please feel free to check out my website, eb2niw.info, or drop a comment in this video.